Good afternoon, everybody. Hello. Thank you very much for joining us this lovely Friday afternoon for the second in our VMG series on navigating redundancy in the veterinary sector. I'm absolutely thrilled to bits to be joined this afternoon by Nick Wadsley. Nick is a senior advisor at ACAS. Thank you very much for coming along this afternoon, Nick. And can we start? Can you just explain for people who perhaps aren't familiar what actually ACAS is and what it does?
Yeah, no, thanks, Hannah, and good afternoon, everyone. Yeah, absolutely. ACAS is we're funded primarily or mainly by the government, and people may have come across us in the past in the relation of dispute resolution. So principally, you'll have heard us in the news, maybe the current industrial action, things like that are going on. We'll be working behind the scenes, speaking to employer, to union, with the aim of trying to resolve disputes on that basis, but maybe even bringing people together and sort of formal conciliation meetings. We do that on a employment tribunal basis as well, so we try and resolve things before they get to court to save the taxpayer money. But we also provide a wealth of advice through our helpline online. So, for those people who want to get a bit more employment law information, good practice advice, certainly go online and have a look at our website. But also we've got our helpline. I'll provide our phone number later on because they can be a useful source of information as well for both employers and employees as well. So that's some of the things we do. We also do training for employers and even workplace mediation as well. So there's a variety of different things, but ultimately it's all about trying to make working lives better for everyone.
Lovely, thanks ever so much. And like Nick said, the ACAS website and helpline have a wealth of useful information on all sorts of aspects of employment law and that kind of thing. So very, very much well worth a look if you'd like any kind of support on sort of employment matters. But this afternoon, we're specifically going to be talking about redundancy. As we are very much aware in the veterinary sector, it's quite a current topic. So Nick has very kindly agreed to answer your questions. So thank you very much to everybody who's submitted their questions. We have quite a list. So if it's okay with you, Nick, we will jump right into questions. So
yeah, absolutely.
The first one, perhaps a bit philosophically, but why redundancy? So from sort of in your experience, from your work with ACAS, why might an employer be considering redundancy?
Yeah, I mean it's an important question, and it does actually link with a lot of the good practice in the law lies behind why organisations choose to make people redundant, because of course there has to be a reason and a genuine reason to do that. But one of those the things that might include in that, it could simply be decisions around money, and often it will very much focused on money. So it's cheaper to carry out work elsewhere. There's a loss of a contract, for example, loss of funding. Could be technology advances, could be work contracted out, reorganization of work, business restructures, transfers, mergers. Ultimately, a wide variety of reasons could be the reasons for considering redundancies. But ultimately, I'll come back to that sort of definition of what redundancy really is, where the work is diminishing or ceasing in either a particular workplace or across sites.
Mm-hmm. Yeah, so I mean, like you said, it's a big thing to be considering. So there has to be the reason for it, the business reason for making that decision, and that kind of follows into the sort of second question, which is an interesting one around the sort of relationship between the sort of size of company or the success of a company, or perhaps the perceived success of a company, and how can we be in this situation where a company that is ostensibly got millions in income, yet there might be a redundancy process going on? So how do we end up here?
I just want to start from one angle of thinking about this question, because actually this ties very much with that sense that, and in our experience, and certainly my own personal experience of redundancies, it is a very emotive situation for everyone involved, whatever angle position you come at. And I think, particularly when you work in organizations where you see lots of money, lots of profit potentially, and of course there are redundancies happening in particular areas. Ultimately, though, it comes back to the definition of redundancy from a legal perspective. And if we look at it from an Employment Rights Act 96 perspective, we have a look, and I use those words ceasing and diminishing. So when particular business, or a place of work where the employee was employed, where the work is diminishing or indeed ceasing, that would make a redundancy valid in that particular place, irrespective of what's going on in other parts of the organization. But I mean, I think one of the key things, though, is that, of course, these questions, these concerns, these issues should be things that, in a good practice sense, people talk about and understand through consultation. And questions like this could and should be asked at that point.
Yeah, absolutely. I think one of the things that we learned from the first session of this we did was that discussion, consultation doesn't just mean, hey, this is what's happening. It is a conversation, or should be a conversation. If people do have these questions, then it's perfectly okay to be asking them. Okay, the next sort of set of questions we've got are kind of specifically to do with sort of the employee's perspective, and some of the actual sort of nitty gritty of the redundancy process. So let's have a look at some of those. So first one is around payment in lieu of notice. So advantages, disadvantages, why might this come up, and is it a good idea to accept payment in lieu of notice if it's offered?
Well, the typical default ACAS answer on this would be, of course, it depends. And the first thing to say is that I think, certainly reading your contract, if there is a clause on pay in lieu of notice, because that would be the key thing. So what effectively pay in lieu of notice means is that ability to pay what you're contractually entitled to in terms of your notice pay, and then you leave work straight away, basically. And it might be something, and again, dependent on the wording of the clause, the employer could actually, or might be able to anyway, insist on. So it's a potential option. Whether you choose to do it or not, I mean, I think one thing to consider would be that the contract ends straight away. So therefore, in theory, you would lose then any contractual benefits that you would be entitled to, which may or may not be an issue dependent on what those benefits are. I mean, if we're talking healthcare, company car, etc., there may be implications. But again, the key is that it's all about the drafting of the clause, and if there is ambiguity there, then it could present potential problems from both sides. So certainly, if you're thinking of potentially being offered pay in lieu of notice, one, check your contract. Two, it's still good practice to have discussions about what the potential implications might be, and then you can assess the advantages, disadvantages as appropriate. So that's I think what I'd say in regards to pay in lieu of notice.
Okay, lovely. The top tip there, obviously read your contract, but just be aware that there may be unexpected impacts in terms of if your contract does end on that day, then you may lose things like access to healthcare, company vehicles. Obviously, in the veterinary sector, can be quite significant, that kind of thing. So just be aware of the implications as well as the termination.
And actually thinking about it, there may be implications in terms of the actual date, in terms of potentially not going to impact many people, but of course, if the earlier date means that you leave on a different date, would that then impact in terms of continuous years service, etc., and therefore have knock-on impacts in terms of other pay, not least redundancy. So I mean, that should be ironed out beforehand, but again, it's things that you want to consider.
Yeah, definitely something to be aware of. It affect things like leave allowances as well, if you've accrued less
potentially
less employment time. So things to make sure that you're considering if that is your situation. Okay, lovely. Another one to do with kind of notice. Can somebody leave before the end of their redundancy notice period?
So the quick answer is, if your employer lets you and you agree,
Right.
then that's fine. I mean, I think that the main thing to say is that, you know, the notice period is still the notice period. So there's still, if you are required and you are working your notice period, the expectation is that you would be there. You know, obviously have a conversation with them. If you just decide to leave at some point during your notice period, or indeed before it starts, then of course that would technically be a breach of contract, which may have implications. So, you know, certainly, you know, think hard and carefully and take advice if you are considering that.
Right. So their answer is, well, yes, you can, but maybe consider whether you should.
Yeah, absolutely. I mean, I think the quick answer is, you know, you will definitely want, if there is, and that sometimes employers do, they'll be flexible in these situations. Redundancy is a difficult time after all, and they'll be more than happy if you say, well, look, I've got another job elsewhere. Is it okay? Well,
Right.
that's fine. You know, that could
Yeah.
potentially be absolutely fine.
Yeah.
So,
Yeah.
quick answer is, though, before you do anything, certainly have a conversation with your employer
Yeah.
about it.
Yeah. I think it's been a bit of a theme as to all these discussions on around redundancy. It's talk about it, discuss.
Yes,
So that kind of thing is definitely a running
absolutely.
theme.
Absolutely. And I will be saying exactly the same, no doubt.
I'm sure. Okay. Another sort of specific situation
Hmm.
question. What, I suppose, if anything, is different for me in the redundancy process if I have a disability?
Yeah, it's an interesting question actually, and one
Mm.
that raises several questions actually. So I think the first, and where my mind instinctively goes when we think about this in relation to redundancy, is the selection criteria.
Mhm.
So if and there will be conversations about how people are going to be selected for
Yeah.
redundancy. And remember, and again, we come back to the central point. This is all sounds quite dry, but it is, you know, when we get into it, a very
Mm.
emotive debate and question. How do we determine who should be who's more valuable to a business than others? And of course, we'll have very personal as well as
Mm.
professional opinions about this. So I think that's important to say. But when we're thinking about the selection criteria, I think one of the key things is, and particularly in relation to disability, you want it to be objective. You want it to focus on areas that, you know, as far as possible, can be objectively judged. So we're talking about, you know, potentially performance, technical ability, qualifications, competencies. You might look at disciplinary record. You
Mhm.
might look at attendance as well. And that's, of course, where the difficulties may start, because of course people's
Right.
attendance, you know, might well be related to a protected characteristic like
Yeah.
disability. You know,
Mhm.
it could be pregnancy as well.
Mhm.
You know, and of course, if you're then saying, well, actually your attendance was not very good, but it was because of your disability, then of course there could well be then a claim for discrimination. So
Yeah.
the quick answer is that you shouldn't treat people less favorably because of their disability. And again,
Mhm.
consultation will be important in determining how the selection criteria are constructed. Um, but you want to try and avoid and iron out any potential areas that are going to
Mhm.
unfavorably or treat people less favorably, and that would be one of them. I mean, if I give the example, if we say, well, flexibility, for example, you know,
Mhm.
we will give a certain weighting to people who are more flexible than others, because that's important in the role. We want people to be flexible. Well, what does the word flexible imply? It could mean a variety of different things, of course. It could be, you know, I'm able to work all hours and all days and weekends and everything
Mhm.
else, or it could be that I'm, you know, a drop of a hat willing to go and, you know, um, go and help out on a different subject area that I'm not confident with, or whatever. It could be different things. But of
Mhm.
course, but that interpretation could mean that, of course, for might be indirectly discriminatory against women who might be, you know, are more likely to be part-time, for example. It could again be, if you have a particular disability that has some restrictions, again, that could be discriminatory towards you. So
Mhm.
again, it will depend on the specific situation, but those could be things that you should look out for. The other thing
Mhm.
I'd say in relation to disability is that reasonable adjustments, you may have reasonable adjustments in place at the moment, but they would be something that is, you know, expected, and there is an obligation on employers to provide reasonable adjustments, of course, but through the process as well. So, for example, it might be, in relation to meetings, etc. So, just making sure that people are
Right.
able to attend and contribute in an effective way. So that's something to think about and bear in mind. So that's what I immediately and instinctively think of when I'm thinking about that question.
Right. That's really interesting. Thank you, because that obviously brings up a lot of other considerations and things like reasonable adjustments. If somebody does require reasonable adjustments in terms of like how you provide meeting information, for example, that reasonable adjustment must be continued into the redundancy process, and that kind of thing. So that's an important
I mean,
consideration.
it may not be applicable in your field, but it might be that, for example, English isn't the first language for some people, and of course
Right.
they need to have someone attending who'll be able to
Mhm.
translate, for want of a better
Mhm.
word. But
Yeah.
that could be an example, for example.
Yeah, absolutely. So that's an important one to consider. Well, on both sides of the process, in that terms of
Absolutely.
employers need to be providing these things, and employees, if that does apply to you, then you can absolutely insist that those provisions continue. Okay, slightly wider question. This one, from an ACAS point of view, what are your top tips to make the process as painless as possible? Now, we've already mentioned that obviously this is it's a legal process, but it's quite an emotional one, and certainly we're seeing in our sector that it's emotionally tough for everybody involved. So, any top tips to how we can make it go as smoothly as could be reasonably expected?
Yeah, I mean, well, I guess there's plenty of things to say, aren't there? But communication, and good communication is clearly really important all the way through. And I think, in referencing your point about the previous session you've had, from an employer perspective, for consultation, it shouldn't just be a mechanical way of distributing information. It's absolutely about genuinely understanding the perspectives, the issues, the concerns, and even the opinions and ideas of the people impacted, so that they can potentially influence and make a difference to things. And it might just be a difference in terms of timescales, but it could also be the essential considerations about, well, actually, are there other options? If we're talking about reducing headcount, for example, well, okay, are there other options that might involve, reducing overtime? Are there other options in terms of, reducing hours, reducing salary? I don't know. All of these things could be potential issues, and consultation would be a good opportunity to discuss them. Now, I'm not saying that you know it gets rid of the pain, because I think it's recognition that absolutely it's going to be, as you've just said, painful for everyone. And I think, importantly, recognizing that actually, yes, it's painful, of course it is. If your job is at threat of redundancy, it's going to be very, very difficult. But also recognizing that people in a position of having to tell other people, or to support during the process, absolutely, you've worked with colleagues for many years, you're going to feel
Yeah.
exactly, very guilty in some cases, that you've got to, be administering a process which ultimately will result in people, losing their jobs. So I think there's got to be a recognition there, but there's also got to be an ability to talk openly and honestly about the potential options that there are. And that good communication should continue throughout. There should be signposting to resources, to services that can support. I know next week you're going to be talking about support for people looking at updating CVs, things like that. All of that can help. I do also think that it's important. I was going to touch on it later, but I think it's important, if you do have services like employee assistance programs,
Yeah.
people are signposted towards them, because they do give both practical and emotional support for people. I think, there's often a sense of bringing people together, in a sense they're in it together, but sometimes that there is division there, because of course some people will be impacted and other people may not be. But I think it's about that emotional intelligence and understanding that, actually we're in a difficult time and we need to be supportive and recognize that together. But I think there's a few other points that I'd say, not going back to the legal side of things, is that alternative employment should discussed as well. So there's no legal obligation on employer to find suitable work or create a new job, but there is an expectation that the employer will consider possibility of alternative work and offer it if it's available. So it's important that, you know, and this could be any sort of job as well. And I think one thing that tends to get forgotten in this is that there's assumptions made about the sorts of jobs that people would want to do or not do. And so sometimes people aren't offered jobs because, oh, actually, we don't think they would want to have that drop in salary, or we don't think they would want to have that particular job because it's not as high status, for example. But actually, you know, in these situations, some people do review their life, their life, how they're doing, how it fits in, and sometimes want to do that. So I think keeping the options as open as you possibly can is important, and that is, as I say, a legal thing that you should, as an employer, consider in terms of, you know, offering alternative employment if it's there. The other thing I wanted to say was time off as well. So the important point on time off, there is, in law, the important point that actually there should be time off if you're in your notice period, and the law helpfully defines this as reasonable paid time off. So what is reasonable? Again, we're in that debate about what reasonable time off might be. But the important thing is that when you are in your notice period, you are entitled to some time off there for job hunting or training or anything, and that should be paid. I think the maximum is 2/5 of a normal week's pay is how they define it from a legal perspective. But ultimately it's going to be a little bit less than that, and what's reasonable will depend on the conversations you have. So again, we're back in the realms of having good conversations about it, and, you know, an understanding employer alongside, an approachable employee who's being clear about what they're looking for in terms of job hunting and training. But that's something that's important just to flag up, and just to make sure that, you know, these things are, you know, an ongoing process, and it is important that people get what they need, the maximum that they can in terms of support. So those are a few points I would say. I think just to summarize though, that communication, the consultation, the listening, the adapting, and the recognition of the situation, I think are really fundamental and important, and the clarity of how you communicate the specific bits of information that are going to be important for people.
Yeah, absolutely. And I think that also answers one of our other questions, which is somebody who is in this situation that you sort of just described, say, well, I'm not affected, but somebody else in my practice, in my workplace is. So how can I support them? And I think it's so important, A, to keep the communication channels open, B, to recognise the emotional impact of what's going on, even for those who aren't actually directly involved. But veterinary practices, they tend to be quite like tight-knit teams. People work together for a long time, people work in quite high emotional situations anyway. And also to flag, just like you said, Nick, so the availability of support services like your employee assistance program, like we have in the veterinary sector a helpline called Vet Life, which is a confidential listening service which can help people in any kind of difficult situation. So if someone would benefit from talking it through, then do make use of those services. Absolutely.
Yeah, I mean, so just on that point, sorry to interrupt, Hannah. I think you know, it is, you know, there's a couple of points I just want to add. I mean, one is the recognition of your own boundaries. You know, I think it's sometimes, and I've seen it from personal experience, people getting very emotively and emotionally involved in the process on behalf of a friend or a colleague, and really wanting to fight the fight, if I can phrase it like that, and then, you know, actually getting dragged into, it becoming very entrenched, it becoming more of a battle than a constructive conversation, and losing sight of it because you're wanting to do the best for the person that you care for. So, you know, again, just recognizing your own boundaries, you know, sort of maybe writing down, thinking about the emotional versus the practical support and where you want to lie in it, and how you can approach different things is I think important. The other point to say, this is a sort of technical point in a way, but the ACAS code of practice doesn't cover redundancies, but good practice will always allow staff to be accompanied at all dismissal meetings. So if there's an opportunity to support your friend, your colleague through that process, it might be something that you could do by going along with them to a meeting. And I think again, most employers will allow that, whether that's a consultation meeting or not, but sometimes, particularly if people are feeling very angry, frustrated, nervous, whatever, having someone else along can actually dampen that down. So that's another area that you might consider in being able to support. What I would also add, I'm just gonna Hannah, just give the ACAS helpline number so that people
can do that
if they want. They can obviously, there you go. Well, I'm not going to do that because you've done that.
as if by magic.
As if by magic. So yes, back to you anyway.
But yeah, it's a useful one to flag that the ACAS website and indeed the helpline practical support advice on for anybody who is currently experiencing sort of redundancy. Okay, couple more questions. So one for kind of perhaps during or towards the end of the process. What are the options if someone thinks that the process has been carried out unfairly?
Yeah, and of course, this does happen, of course, and whether the the actuality or the perception, but either way, people will feel that things haven't been done fairly, whether it's the administering of the selection criteria, whether it's the lack of consultation, whatever it is. Of course, there will be issues. I think the first thing to say in the default position, and what ACAS would always say, would be, of course, we'd expect everyone to try and resolve the issues informally wherever possible. So you would want to have the constructive conversation. You'd want to highlight exactly what your concerns are, give the employer that opportunity to try and resolve it and address the issues, whatever they might be. And then hopefully that will at least create a constructive dialogue. But of course, accepting that's not always going to happen. So, there may be, and it depends on the policy and procedure that you have, but I would certainly refer to your internal processes, which may involve formally appealing decisions, or it might be a formal grievance that you decide to put in. That can be an option, and certainly, you'd want to try and exhaust that before going down the final option, if you like, which would be, of course, looking at potentially thinking about an employment tribunal claim. So if you do think that the process has been unfair, it hasn't been resolved, you've gone through the formal process, then the process for that is to notify ACAS. So this isn't our helpline or website, but there is a link on our website, but you would simply do an online notification. Then you would speak to ACAS. We would potentially speak to the employer if that's what you wanted. The aim being to try and resolve it before it goes to tribunal. If it doesn't, then what happens is you get a certificate. You then can make an employment tribunal claim with that if you wish. Then that will be a sort of formally lodged with the tribunal, and then the legal process, as it were, would start. What I would say on that is that again, ACAS have another opportunity to try and resolve it. But of course, if you do feel that the process has been unfair, you feel that you've exhausted every option, and you feel that there is value in going to a tribunal claim, that's of course your right. And then, the tribunal judge would make a decision on the basis. I could talk a bit more about what the tribunal process might be if you think it might be valuable, but in terms of redundancy.
Yeah, please.
So, I think what a tribunal primarily are looking at in terms of redundancy processes is firstly, they do, and in redundancy dismissals, they do look very hard at the process. They'll be looking very much, well, one, they'll have to make that assessment about whether it's a genuine redundancy or not. They're not going to, you know, religiously exhaust sort of, you know, every single angle of the business decision for it, but they're going to have, you know, see some kind of rationale. And then they're not going to substitute their view, though, of course. What they'll do and be very keen to understand, has there been consultation, and what was the process followed, and was it a fair process? Will they they'll look at the selection criteria, etc. Sometimes tribunals make decisions that actually the dismissal was unfair, but I'm sorry, because of the process, but the dismissal would have happened anyway, so they can reduce compensation. The other thing to bear in mind, and I think this is one of the crucial things from an employment tribunal perspective in redundancy situations for an employee, is that if you are successful, the tribunal will look at compensation, but dependent on the redundancy pay that you've had, that will be eaten into, for want of a better way of explaining. So there's a basic award, which is the equivalent of a statutory redundancy amount. So you wouldn't get that if you've been paid a statutory redundancy amount. If you get a contractual enhancement, then again, that would be eaten into any compensation. And compensation's based on what you've lost, i.e., you know, if you've been out of work for X amount of time, or if you've got a new job at a lower salary, whatever it might be. So if you are successful, that's how they would determine it. So I think the reason I mention that is, of course, it's, you know, some people feel very strongly that it's been unfair, and of course want to go to a tribunal because, you know, it's an opportunity to, you know, get justice, for the sake of a better word. But I think sometimes it's that separation from the emotional and how you feel about it emotively to actually what are, you know, the realistic and the rational way of approaching it, which might still lead you to the same place, of course. But what ACAS can do at a conciliation basis is talk through all of that with an individual. So if an individual is thinking about it but not sure, they can ask questions about what the law says in regards to this, as well as talking through the tribunal process, which gives people better and more informed choices about what they want to do.
Yeah, fantastic. Well, that's hugely useful. Thank you, Nick. I think the last question we had is perhaps one for next week's session, because people are asking, like, where can I find help with my CV or finding a new job? So if you are affected by redundancy, and if it turns out that your job is one that is actually made redundant, then I will going to recommend next week's session. So next week we are handing over to our lovely colleagues at Vets Stay Go Diversify, and they, in conjunction with VDS Training, are putting on a session next week. It's Tuesday the 18th of July. It's an evening session, that one, at 7 o'clock, and they are going to be looking at what they call reframing redundancy. So if you have been made redundant, what are the next steps? They're going to be looking at marketing yourself in the workplace, thinking about moving on, where your next steps might be. And they've got a wealth of experience in career support for vet folks. So I'm going to recommend that session next week for them. I'll pop the details up there. I'm also going to pop the ACAS contact information up as well, just so that if you would like to speak to one of Nick's colleagues, presumably, on the ACAS helpline, then they are there and available to support you in those kind of elements. Okay, Nick, thank you so much for bringing your expertise along. Thank you very, 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 very much. It's been massively valuable to hear about some of the different options we have, some of your incredibly experienced and valuable advice for folks that have been affected. We're really, really, really grateful. So thank you very much. Everybody watching, thank you very much for joining us. This session will be up on our social media channels if you need to watch back, or if you would like to refer it to anybody else who may find this discussion useful. Do join VSUD next week, Tuesday the 18th at 7 o'clock. We will see you then. Thanks ever so much, folks. Bye-bye.
Thanks. Bye-bye.